Welcome! Today, we're diving into the concept of rent abatement, a term you might have come across in lease agreements or real estate discussions. Rent abatement is a crucial topic for both tenants and landlords, especially when negotiating lease terms or dealing with unexpected events. In this video, we'll break down what rent abatement means, when it's typically used, and how it can impact your financial obligations. Whether you're renting a home, an apartment, or a commercial space, understanding rent abatement can help you make informed decisions and potentially save money. Let's start by defining the term and exploring its basic principles. Rent abatement refers to a temporary reduction or suspension of rent payments, typically granted by a landlord to a tenant under specific circumstances. This relief can be partial or full, depending on the agreement between both parties. Rent abatement is not the same as rent forgiveness. Instead, it usually means that the tenant is allowed to pay less rent or no rent at all for a set period, often due to property damage, construction delays, or other disruptions that make the space unusable. Understanding this distinction is important for both tenants and landlords when negotiating lease terms. Rent abatement often comes into play when a rental property becomes partially or fully uninhabitable. For example, if a commercial space is under renovation and cannot be used for business, the landlord might offer rent abatement until the work is complete. Similarly, if a residential apartment suffers significant damage from a fire or flood, tenants may be granted abatement while repairs are underway. These scenarios highlight how rent abatement serves as a form of protection for tenants, ensuring they aren't paying for a space they can't use. Most lease agreements will specify the conditions under which rent abatement can be granted. These clauses are important because they set clear expectations for both parties. For instance, a lease might state that if the property is damaged and cannot be occupied, the tenant's rent will be reduced or suspended until the issue is resolved. It's essential for tenants to carefully review these clauses before signing a lease, as they outline the rights and responsibilities in the event of unforeseen circumstances. It's important to distinguish between temporary and permanent rent abatement. Temporary abatement is the most common, lasting only as long as the property is unusable or until repairs are completed. Permanent abatement, on the other hand, is rare and usually only occurs if the property is permanently uninhabitable. In most cases, once the issue is resolved, the tenant resumes paying the full rent as agreed in the lease. Understanding the difference helps tenants and landlords plan for various scenarios. Rent abatement is often confused with rent deferral, but they are not the same. Rent deferral means that rent payments are postponed to a later date, but the tenant is still responsible for paying the full amount eventually. With rent abatement, the tenant is relieved from paying rent for a certain period, and those payments are typically not required later. This distinction is crucial when negotiating lease terms, especially during challenging times like economic downturns or natural disasters. For tenants, rent abatement can provide much-needed financial relief during difficult times. If a property becomes uninhabitable due to circumstances beyond their control, tenants are not forced to pay for a space they can't use. This protection can be especially valuable for small businesses or families facing unexpected disruptions. By including abatement clauses in lease agreements, tenants can safeguard themselves against unforeseen events and maintain financial stability. While rent abatement benefits tenants, landlords must also consider its impact on their income. Granting abatement means temporarily losing rental revenue, which can affect their ability to cover mortgage payments or property expenses. However, offering abatement can help maintain good tenant relationships and prevent vacancies. Landlords should weigh the short-term loss against the long-term benefits of tenant retention and property reputation. Negotiating rent abatement terms requires clear communication between tenants and landlord. Both parties should discuss potential scenarios that might trigger abatement, the duration of relief, and any documentation required. It's wise to put all agreements in writing to avoid misunderstandings later. Open dialogue and mutual understanding can lead to fair solutions that protect everyone's interests. When requesting rent abatement, tenants may need to provide documentation proving that the property is unusable. This could include photos of damage, repair estimates, or official notices from authorities. Landlords might also require written requests or forms to process the abatement. Keeping thorough records ensures that the process is transparent and that both parties are protected legally. Insurance can play a significant role in rent abatement situations. Some landlord insurance policies cover lost rental income during periods of abatement, while tenant insurance might cover temporary relocation costs. It's important for both parties to review their insurance policies and understand what is and isn't covered. This knowledge can help minimize financial losses and speed up recovery after a disruptive event. Rent abatement can apply to both commercial and residential leases, but the terms and triggers may differ. In commercial leases, abatement is often negotiated as part of the initial agreement, especially for new businesses or during property renovations. Residential abatement is more likely to be triggered by emergencies, like fire or water damage. Understanding the differences helps tenants and landlords prepare for their unique situations. Lease agreements often contain specific language regarding rent abatement. For example, a clause might state, if the premises are rendered uninhabitable by fire, flood, or other casualty, rent shall be abated until the premises are restored. It's important to read and understand these clauses, as they determine your rights and obligations if an unexpected event occurs. If you're unsure, consider consulting a legal professional. Force majeure clauses in leases can also trigger rent abatement. These clauses cover extraordinary events like natural disasters, war, or government actions that prevent tenants from using the property. If a force majeure event occurs, tenants may be entitled to rent abatement or other relief, depending on the lease terms. It's wise to review these clauses and understand how they interact with abatement provisions. Sometimes, only part of a property is unusable, leading to partial rent abatement. For example, if a commercial tenant can use only half of their office space due to repairs, the landlord might reduce the rent proportionally. This approach ensures fairness, as tenants only pay for the usable portion of the property. Both parties should agree on how the reduction is calculated and documented. Calculating the amount of rent abatement can vary depending on the lease terms and the extent of the disruption. Some leases specify a formula, such as reducing rent by a certain percentage for each day the property is unusable. Others may require negotiation based on the situation. It's important to document the calculation method in the lease to avoid disputes later. Both tenants and landlords have legal rights and protections when it comes to rent abatement. Local laws may dictate when abatement is required and how it should be handled. For example, some jurisdictions mandate abatement if a property is deemed unsafe by authorities. Knowing your legal rights can help you navigate disputes and ensure fair treatment. Common triggers for rent abatement include fire, flooding, structural damage, or utility failures that make the property uninhabitable. Sometimes, government orders or public health emergencies can also trigger abatement. It's important for both tenants and landlords to understand what events qualify and how to respond when they occur. Even during rent abatement, tenants may still have certain responsibilities, such as maintaining insurance or notifying the landlord of issues promptly. Failing to meet these obligations could jeopardize their eligibility for abatement. Always review your lease to understand what's required during an abatement period. Landlords also have duties during rent abatement, such as making timely repairs and communicating with tenants about progress. They must follow local laws and the terms of the lease agreement. Failing to act promptly can lead to legal consequences or further financial losses. In some cases, if a property cannot be restored within a reasonable time, the lease may allow for termination instead of continued abatement. This protects both parties from being locked into an unworkable situation. The lease should specify the conditions under which termination is allowed and the process for ending the agreement. Let's look at a real-world example. A retail store leases space in a shopping center. Due to a burst pipe, the store floods and must close for repairs. The landlord grants 2 months of rent abatement while the space is restored. This allows the business to recover without the burden of rent payments during the closure, and the landlord retains a long-term tenant. Consider a family renting an apartment that becomes uninhabitable after a fire. The landlord offers rent abatement for the duration of the repairs, and the family temporarily relocates. This arrangement helps the family avoid financial strain and ensures the landlord fulfills their legal obligations. Rent abatement is sometimes used during major construction or renovations that disrupt normal use of a property. For example, if a landlord is upgrading building systems and tenants can't access their space, abatement may be granted for the affected period. This encourages cooperation and minimizes disputes during necessary improvements. During events like the COVID-19 pandemic, government orders sometimes forced businesses to close. In such cases, tenants and landlords often negotiated rent abatement to share the financial burden. These situations highlight the importance of flexibility and open communication in lease relationships. If a tenant subleases their space, rent abatement can become more complex. The original tenant remains responsible for the lease, but the subtenant may also be affected by disruptions. It's important to clarify in the sublease agreement how abatement will be handled and who is entitled to relief. Rent abatement typically does not affect the security deposit unless the lease states otherwise. The deposit remains in place to cover damages or unpaid rent outside of the abatement period. Both parties should review the lease to understand how abatement interacts with deposit terms. If a lease includes scheduled rent increases, abatement may temporarily pause these increases during the relief period. Once the property is usable again, the rent typically resumes at the agreed-upon rate, including any scheduled increases. It's important to clarify this in the lease to avoid confusion. During rent abatement, tenants may still be responsible for utility payments depending on the lease terms. If utilities are unusable due to property damage, the lease should specify whether these charges are also abated. Clear language helps prevent disputes over utility bills during the abatement period. Property taxes are usually the landlord's responsibility, but rent abatement can affect their ability to pay. Some landlords may seek tax relief from local authorities during extended abatement periods. Understanding these financial dynamics can help both parties plan for long-term disruptions. Landlords with mortgages may face challenges during rent abatement, as their rental income is reduced or eliminated. Some lenders offer mortgage forbearance or relief programs in these situations. It's important for landlords to communicate with their lenders and explore available options. Property managers play a key role in administering rent abatement. They coordinate repairs, communicate with tenants, and ensure that all documentation is handled properly. Effective property management can make the abatement process smoother and less stressful for everyone involved. If tenants have made improvements to the property, rent abatement may affect their investment. For example, if a tenant-funded renovation is damaged, the lease should specify whether abatement applies and how repairs will be handled. Clear agreements protect both parties' interests. When renewing a lease, tenants and landlords may revisit abatement clauses to reflect new circumstances or lessons learned from past experiences. Updating these terms ensures that both parties are prepared for future disruptions and that the lease remains fair and relevant. Disputes over rent abatement can arise if tenants and landlords disagree on eligibility, duration, or calculation. Many leases include dispute resolution procedures, such as mediation or arbitration, to resolve these issues without going to court. Knowing your options can help resolve conflicts efficiently. It's important to note that rent abatement is not the same as rent forgiveness. Abatement is a temporary relief, while forgiveness means the landlord permanently waives the rent owed. Understanding this difference is crucial when negotiating lease terms or seeking relief during hardships. Rent concessions are another form of lease incentive, but they differ from abatement. Concessions might include free rent for the first month or reduced rent as a move-in bonus, while abatement is typically triggered by unforeseen events. Both can provide financial relief, but their purposes and timing are different. Market conditions can influence the likelihood of rent abatement. In a tenant's market, landlords may be more willing to offer abatement to attract or retain tenants. During economic downturns, abatement can help both parties weather financial challenges and maintain stable occupancy. Rent abatement typically does not affect a tenant's credit, as it is an agreed-upon relief. However, if a tenant stops paying rent without an abatement agreement, it could lead to negative credit consequences. Always ensure that any abatement is documented and approved by the landlord. During abatement periods, landlords may pause rent collection systems or adjust billing statements to reflect the relief. It's important for both parties to keep accurate records and confirm any changes in writing. This helps avoid confusion and ensures that everyone is on the same page. Clear and timely communication is key during rent abatement. Tenants should notify landlords as soon as possible about any issues that might trigger abatement, and landlords should respond promptly. Open dialogue helps build trust and ensures that the process runs smoothly. Documenting every step of the abatement process is essential. This includes written requests, landlord approvals, repair estimates, and any changes to rent payments. Proper documentation protects both parties and provides a clear record if disputes arise later. If you're unsure about your rights or obligations regarding rent abatement, it's wise to seek legal advice. An attorney can review your lease, explain local laws, and help you negotiate fair terms. Legal guidance can prevent costly mistakes and ensure that your interests are protected. To sum up, rent abatement is a valuable tool for managing unexpected disruptions in rental agreements. It provides temporary relief for tenants and helps landlords retain good tenants. Understanding the terms, triggers, and processes involved is essential for both parties. Always review your lease, communicate openly, and document everything to ensure a smooth experience. Thank you for joining us to learn about rent abatement. Whether you're a tenant or a landlord, being informed about abatement can help you navigate challenges and protect your interests. Remember, every lease is unique, so always read the fine print and consult professionals when needed. Stay proactive, communicate clearly, and you'll be well prepared for whatever comes your way in the world of renting.